Lordship, we filed grounds of opposition on the 2nd of July 2025 and also filed our submissions on the 3rd of July 2025. Your Lordship, I associate myself with the submissions by Mr. Oraro and the fact that the application before you is res judicata. The issues therein having already been determined, and as we submit that it offends the finality, the principle of finality in litigation. The substratum thereof having been fully determined by this Honorable Court by one Justice Mugambi in his ruling dated 25th of April 2025. Your Lordship, yes. Your Lordship, at paragraph 84 to 90 of the ruling by Justice Mugambi, the court decisively held that the Chief Justice is the only constitutional holder authorized to assign judges for such matter, and further affirmed the doctrine of necessity. This court expressly rejected the arguments that have now been recycled in the application that is before you. Secondly, Your Lordship, on the question of whether the empanelment by the Chief Justice is unconstitutional, where she's a party to the petition, this is our submission. Your Lordship, the assignment of judges is a constitutional obligation conferred to the Chief Justice in her institutional capacity. Your Lordship, we wish to bring to your attention the decision in Kenya Medical Research Institute versus Attorney General. The same is listed as authority number 3 and appears at pages 19 to 26 of the second petitioner's list of authorities. Your Lordship, in that decision, the court expressly stated that as opposed to similar functions that were found in the previous constitution, the power of empanelment granted under the current constitution is a constitutional mandate. It is hinged on a constitutional provision, specifically Article 165(4) of the Constitution. Your Lordship, in advancing this argument, the first interested party has made reference to the case of Yakub versus the Queen. Your Lordship, that decision is distinguishable from the present matter for the following reasons. In that case, the issue arose in the context of a judge exercising judicial authority in appointing a panel to hear an appeal against his own ruling. Your Lordship, by contrast, in the present case, the Chief Justice exercises administrative function under Article 165(4). The Chief Justice does not in any way participate in adjudication of the dispute. Your Lordship, the reliance on that decision is not necessary for reason that there is no lacuna in law on that issue, as the same is settled under Article 165(4) of the Constitution. On the issue of recusal, Your Lordship, we want to make reference to the decision of Justice Mugambi at paragraph 88 of the ruling. This is what the court said. It is therefore untenable to imagine that judges assigned to hear the matter by the Chief Justice are subject to her control, and that the Chief Justice will direct the outcome of the petition. Your Lordship, the court relied in the case of Gashuri versus Attorney General. The same is listed at paragraph 5. Listed as authority number 5, and we wish to rely on that same decision, where the court said at paragraph 60, in that respect, any suggestion that this bench and indeed any other judge in this country cannot and should not hear this petition is not only strange, but also will cause an injustice. This is so because the effect of such a move would be that the petition cannot be heard, and that as a result, it would never be known whether an impugned decision violates the Constitution as well. Your Lordship, we submit that judges are not beholden to the Chief Justice. Their independence is constitutionally guaranteed under Article 160, and they're expected to decide matters solely based on the law and evidence presented. Your Lordship, the applicant's contention at paragraphs 31 and 34 of the affidavit that there is a likelihood of bias merely because the appointment was made by of some of the judges were made by the current Chief Justice is, with respect, misconceived and unconstitutionally unsustainable. The issuance of such letters is purely administrative, a function exercised by the Chief Justice in her institutional capacity. It is the JSC that recruits the judges, and it is not the Chief Justice in her personal capacity. To that end, Your Lordship, I wish to submit that under Article 166B, 1B of the Constitution, all judges of the High Court are appointed in equal capacity and exercise the same judicial authority regardless of seniority or background. Your Lordships, there is no provision whatsoever in the Constitution or statute that accords greater adjudicative weight to any of the judges. None at all. We thus humbly submit, Your Lordships, that the application for recusal is wholly without merit and does not meet the threshold that has been set out. We humbly pray for dismissal of the application with cost to the second petition.